No,
Yeah, yeah.
I'm
I'm
not
like,
seeing it on the phone, man. You're not there.
says live.
Yeah, well, guess we're
I see.
live. Are we
I see.
live? Does anybody in the comments
I
see us?
see numbers. I see numbers on the screen.
Oh, well, I mean, it says live, but oh, here we go. All right, there was a delay. Yeah.
Oh, there's a delay. Come on now. All right. So JR has a little bit. Good afternoon, good evening, whatever. Not legal advice, and it is not legal advice, and it's not financial advice. Although we're going to talk about stuff's financial. We decided since the stuff was fairly complicated, we think that we try to be as transparent as possible in terms of what the potential acquisition was. We kind of give you our thoughts and what we think the issues are, and then we kind of let you decide. But most importantly, and I think JR will have a few things to say about it, most of all, we want you all to participate to the extent you can. So that means like there's a hearing on the 19th. If you can state your piece in a succinct and persuasive matter, we would love you to do so, because I was informed, nothing that's binding, but I was informed that the judge would be impacted by if there were a significant amount of shareholders who succinctly presented their position, that he could be influenced in terms of making a decision. Before we kind of go through it, might as well kind of start on a starting point is, so my understanding, and I don't have any firsthand knowledge of anything, and we're giving you our best interpretation based upon what we know and our experience, whatever. But my feeling at this point in time is that unless the judge gets information or persuaded that he would be inclined to go forward with this acquisition. And the reason why, as at least I understand it, and it's kind of in the moving papers. So there was a motion filed and there's papers. It's kind of in there a little bit. But the reason why is that apparently the receiver, and I don't dispute this, the receiver believes that in order for this company to continue operating, two things have to happen. They need audited financials, which is ongoing, and they need to have to show some kind of business operation. And I guess a lot of you, when you were dealing with your dividends, you probably recall there was a letter that was generated by counsel for Gtii. I think it was from Mr. Markowitz, I believe. I'm not certain, but it said it wasn't a shell, and that was to avoid issues that might arise with regard to the shell company. And if you recall, that issue about the shell caused problems with regard to the issuance of the dividend itself. But anyway, do you have anything you wanted to say preliminarily?
No, I mean, we might as well just dive right into it. We both read the deal. I read it. I finished reading it about, 20, 30 minutes ago. We're just here to provide information. We're not here to help form your opinion. You're going to have to do that on your own. But, the reality is what the receiver is saying is in order for the company to really continue, they need to take this deal. So the inverse of that is if they don't take the deal, the company's likely going to be liquidated in bankruptcy.
Yeah.
That's
So really three choices. Your opinion could be you like the deal, you agree with the deal, or maybe you agree with the deal because you think that's the best alternative. You disagree with the deal and you don't want it to go through, or you want something in between. Maybe you want the terms modified of this particular transaction. I don't know, some of you may not know, but there were prior, at least on paper, since I don't know, but there appears there were prior negotiations involving attempted acquisitions involving GTII. And if you looked at those deals, they usually involve the company that was being acquired would get some amount of shares, 20 million shares, something like that. 20 million seemed to be like the common number, but they would get 20 million shares, and that was the compensation. So why don't you start and kind of reference points that at least caught your attention?
Well, at the outset, let's say this. If you plan on attending the hearing, please be dressed appropriately. Remember, this is a court hearing. You're going to be talking directly to a judge. There's going to be attorneys listening. You need to be presentable. You need to Be as articulate as you can, and you need to be professional. If you want the judge to seriously listen to what you have to say, you need to be professional. That doesn't mean you have to be, in a suit and tie. That's not what we're talking about. You use appropriate language, you don't curse, you don't raise your voice, you simply state what your opinion is. You can have passion in your voice, absolutely, but you have to keep it professional. Otherwise, the judge it's going to go in one ear and out the other, and if you really piss them off, they're going to cut you off. It's that simple. So look the part, pretend to be the part, and when you get off, then you can curse and swear all you want, but you got to be professional. You can't go into this and lose your shit.
Now and along those lines, so that is scheduled for at 9:30 Pacific time on the 19th. And there's a Zoom link that I think everybody has seen. It's on the GTII receiver site. I'll have JR at some point in time post it too, just so we have it on there. Thank you, JR, for volunteering for that.
So the other thing is Ramiro Garcia. I see you say, I want the less worse of all options. Which should we do? We're not here to tell you what to do.
Yeah, we're just going to tell you.
We've never been here to tell you what to do. We're here to talk about it, provide education on what's in the deal, maybe provide our opinions, but I'm not telling you what to do here. You've got to make that decision for yourself.
Now, I do agree with the receiver that in order, because I believe, and I've wondered, and JR and I have talked about this probably for months or many months, probably like a year. At some point in time, there might be regulators that get involved. And if regulators get involved, that might change the character of how it's going. And we don't know when that might happen. And that might impact whatever is going on here in terms of speed or terms. That has to be considered too, because the receiver really believes that if there's not a valid, I think it's the way the term is in the order, has to be a viable business. Without a viable business, he doesn't believe that GTI can continue. And I'm going to accept that as true.
Well, yeah, I think
go ahead.
We've talked about that for months. Right. So
So go ahead.
No, I was just going to say, we know the company's a shell. We know that the board of directors was abusing their role. That's all stuff that was outlaid in the last, all three receivers reports. So yeah, in order for the company to continue moving forward, the receiver is right. There's got to be a deal. I don't know if this is the better deal or not. Richard wanted me to point out some things that I saw. So I read over the agreement. Hold on, I gotta look at my phone because I took screenshots. So I apologize for not looking at the camera. Some of the things that caught me, right off the bat that give me pause for concern here. Terms of the Series B preferred stock. This is in the agreements that they put forward for the deal. Section 3, each share of Series B preferred stock shall have super voting rights in an amount equal to 100% of the total vote of all outstanding shares of common stock and shares of preferred stock. So right off the bat, if this deal goes through, you're losing your voting power. I can tell you right now, whoever holds the Series B preferred stock controls the company. So you've basically lost all your control. Okay.
Now let me jump in. So now that's just a part of the problem. Now I spoke with somebody who said that what was intended by that paragraph is not what's stated. So what I understood was this person told me that what was intended was, or at least what they were told, was it was only supposed to be 100%. So that literally they would have control, but it was like a 50-50 push. The way it's written, it in essence, day one, you now have 1/1000th of the voting rights you did before.
Right.
And again, if it was like Tesla coming in and they were going to bring in, $500 million and GTI was going to fly, whatever. But we don't have the company that's coming in may end up being a fantastic company.
Right. We don't know.
But right now it's purely speculative.
Yeah.
And if it wasn't that, they wouldn't be here. Right.
Right.
If they were so well situated that they had access to capital, they wouldn't be approaching GTII despite It's fantastic. 15,500 shareholder base. By the
Well,
way,
let's
in all the paperwork, just so the shareholders know, in the paperwork that's been filed, the shareholder base is designated as the value that these companies have interest in. Now, a lot of the shareholders have interest in the company because of the short position, not because of the technology of GTII.
right. I mean, we all know why we're here, and why we were here was because of the perceived short position. So I want to go back. There's two really good points here. Donna M, will GTII only be making one deal? Donna, no one is knocking down the doors of GTII to make a deal.
No,
Okay?
but that's a good question. They might,
It is a good question.
I presume they might make a lot of deals. What my concern, so I'm going to jump to that answer. What my concern about this deal is that there will be a huge cash drain. And to me, if you read through it, all that's going to happen is this company that's a tech company that basically, and again, there's no license agreement, although they say there will be a license agreement. The funding for that company is not set. It's a letter of intent. That particular document also gives away equity of the company that's being acquired, and it doesn't say what it is. So the concern, therefore, is that whatever, it's a new company, has 30,000 users, it's trying to expand its user base, it sets forth a whole program of things it must do to get to monetize what it needs to do. So what does that mean? Where's that cash going to come from? There is no cash.
Right. They're not bringing, they're potentially bringing $1 million.
I don't think they're bringing anything. I think that $1 million.
No, they're potentially, and I say potentially because that's what the letter of agreement outlines.
I don't think that's what it says. I think what it says is that that company, Hudson Capital, I think it's Hudson Capital, is agreeing to give invest $1 million to be spent on certain specific items that have to be mutually agreed upon.
Development, marketing, operational expenses of the platform.
And continue.
Mutually agreed on by both parties.
Yeah. So, and then it says there's another section that says that they can get equity in the company. It's going to be negotiated down the road.
Right. And there's a key term in there, and I'm going to read it. And I know everybody on here is going to know exactly what it means when I say it. Investment structure. The investment may be structured as one, equity. Here it comes, convertible debt, or another form subject to further negotiation and agreement. We all know what convertible debt means. Convertible debt is synonymous with toxic funding. Okay. So, this organization, the only way they're going to be able to raise funds is through issuing common shares or convertible debt. Now, they're already contemplating an equity or convertible debt as part of this $1 million loan that they're getting through HBC. $1 million, they're going to burn through $1 million quickly because
by the way,
funds.
By the way, that is one of the shortcomings. Also, we don't have their burn rate, and the agreement, at least the draft agreement that was signed, says that it's subject to due diligence of both sides. That there's not schedules that are attached because the parties haven't completed the due diligence.
And so let's just take a logical step back. If you're a company and you're trying to find an organization to acquire or merge with, common sense dictates that you find a functional organization. So part of what I am concerned about with this deal is that they are looking at GTII and they do want to merge with GTI or acquire GTI. And I have to ask myself, why on earth would a viable company want to pick up a company that's in receivership right now? And they're in receivership because their board, the old board, the previous board, has drained the funds dry and basically abused the company. You have to ask yourself that question. And I think that's a legitimate question to ask if you're in the court. Why? Why are you looking at this organization? Because that tells me you haven't found a decent organization to merge with. And if you haven't found a decent organization to merge with, why? So the concern I have is we've got a pile of shit that we're in right now, and now we're just reducing the pile of shit we're in.
Yeah.
And that's how I see it.
Now, one issue, but again, I'm going to say it, is it still could be the best thing to do, even if it sucks. That's kind of like, because ultimately, do you want the SEC to take it over? Do you want it to go out of business? Do you want to like roll the dice and see what happens?
Right. I mean, because let's take a step back. Because rolling the dice to see what happens, how much worse can it get? Right? Where's the share price at today? Because I don't know.
Well, we know. Actually, we know what's going to happen. This is what's going to happen. Let's see. And to those of you who've been in MMTLP, Fallen Mullen, those kind of cases, you know what's going to happen. We're going to dilute. We're going to do a reverse, so we could get diluted again when they short it again. So in reality, I think I have 21,000 shares, something like that. I was thinking about this kind of because I knew you were going to ask this question. So I think that's worth like $300 today, maybe $300. If I could sell it, but I can't sell it. So I got to figure when they're done diluting, it's probably worth like 30 cents. So, and that's 20,000 shares. So, some people have bigger amounts, some people have smaller amounts. So I think that very fact that what ultimately I'm going to get out of it and the way I equate. And by the way, so between just so you kind of know, between JR and I'm the good cop. I'm supporting the deal. JR is the bad cop.
I'm playing the bad cop here.
But it's kind of like the way I see it is like a class action, right? There's some big class action and you end up getting like a 40-cent coupon off a chocolate bar. And that's the remuneration. So kind of one thing we talked about is, and something that if everybody consider, and everybody's going to have a different thought process, but if ultimately this is the best out, is it something we really want? And maybe it's out of order, maybe it's out of sequence. Because, again, I'm not trying to be critical of the receiver, but perhaps there should have been a business that brought immediate revenue into the company and not a drag that would completely sell out the 15,500 so important shareholders that everybody claims existed. If there was a company that brought in revenue, then I understand that. That to me would be a viable business, because again, it has to be a viable, that's the terminology, a viable business. I don't know if like a company that has zero revenue, I don't think we know if it's viable or not. Right. I think it's to be determined.
I mean, they have zero revenue, so they got to get money from somewhere, and that's what gives me pause for concern, because the only where, and if you read the receiver's report, even says it on page 2, this deal is good because it'll allow, getting the audited share, or getting the audited aggregate, I was going to say audited aggregate share count from MMTLPDs, getting the financials audited and completed and getting it relisted on the pink sheets makes it viable to raise funds. He says it right on the second page. So
yeah, and let me explain also the deal, just so we understand the deal. The way this deal works is there's a company, I think it's called Tradeverse, and the receiver indicates that he was familiar with this back, I think, to 2021. And this company, Tradeverse, is a tech company, I guess, an AI company, and they had some projects that they thought would be good. So what they wanted to do was they wanted to find a company that helped them develop these AI platforms. And, since this time everything's AI, I guess they thought, why not? So the company, Tradeverse, who's not the target, because AI Versity is the target, apparently, although we haven't seen the document, has a licensing deal with AI Versity. We don't know what that is, and we need to know what that is before we understand what we're actually getting, besides the fact there's a cash draw. But in the end, again, I have to say this, it still could be the best choice under the circumstances. I happen to think that it's premature. For example, the Series B shares. So what happened was there was
I'm just pulling that up in the agreement.
Yeah, I think it's December 27th. The company authorized the issuance of 1,000 Series B preferred shares, and they were issued because they were going to do a merger deal with these guys. And these particular shares affect the rights of common shares because they, as we say, they gave super voting rights to something else. So whatever voting rights that we had, they altered. So the question is, prior to doing that, aren't they required to give notice to us as shareholders? I know recently, because I follow them, MicroStrategy did authorize the issuance of like 10 billion common and some number of million preferred, and they had a shareholder vote. And I think it's improper for there to have been the issuance of shares that affected our voting rights without us having a chance to comment, see. And beyond that, if we had seen what they drafted, we could have corrected. If in fact there's a error in the way it was drafted, that could have been corrected. And it wouldn't be, because I think it's embarrassing, to be quite honest. They come in here with documents that aren't even like drafted with any great skill. And it's not by the way, so there's two sets of counsel. I don't know who drafted this. I know it's not the litigation counsel. I know it's corporate counsel. I think it's sloppy. I think it's sloppy work and it's not accurate. And the fact that it's sloppy also gives me concern, to be honest. That's something that it shouldn't be. But the fact they didn't give notice to shareholders, I think it's completely improper, in that the very merger agreement refers to those preferred B shares. So I think it's, in my mind, again, this might be the greatest deal of all time, but seems like to me it's being rushed, and it's being rushed because this is the way I see it. The receiver, and I don't know, again, the receiver feels like there's somebody breathing down his throat, and he's concerned if he waits another day that the company could be shut down. So that might be a valid concern. But on the same path, they've chosen just kind of the fast track and just to get anything done. I mean, I have 5,000. I was thinking about this. I think they said they have 30,000 users. I think between X and YouTube, I have like 10,000. So I'm willing to do it for just 50% of the shares. So I'll take, if instead of doing the business with AI Versity, let's do it with not legal advice. I will be the business, and I will do it for a much smaller share count.
I'm like you. There's a reason it's being rushed, and I mean, I can speculate, but that's all I can do. But I'm going to.
Yeah, but that's something. Unfortunately, that's something that we all have to consider too, because there may be practicalities that we don't know about that influence all these decisions.
Right, and I mean, you and I can speculate, but at the end of the day, we don't know. But I do feel like this is being rushed. I do feel like this was, the fact that they're still doing due diligence on their end on, the whatever we want to call it, loan that they're getting from HBC.
Yeah.
I know in my heart of hearts that the only way this organization is going to raise money if they do acquire GTII is they're going to start diluting. They're going to they're going to do reverse split. They're going to wipe out, half our equity or whatever.
Well, and let's be clear again, because we're trying to be fair. That might happen anyway, right?
Right.
No matter what. The difference is that we don't necessarily have to lose voting control too at the same time. Right? I mean, that's the point. And again, this might be a fine deal. It's just the terms as stated are not fair.
Well, let's talk about what the alternative is, right? Let's talk about what the alternative is. The alternative is the company gets liquidated.
Yeah.
I mean, that's the bottom line. Company gets liquidated, goes into bankruptcy, gets liquidated, assets are gone, we're all wiped out. Okay. So you have to kind of weigh it. Do you get wiped out in bankruptcy and be done? or do you straggle on for another year? You go through a reverse split. So, to your point, we both have 20,000 shares. That's worth about $400. So let's just say they do a 2-for-1. Now all of a sudden or no, they have to do more than a 2-for-1 because they want to get it up. So
Yeah.
really,
100 to 1.
100 to 1. Realistically,
Yeah.
we're gonna, we'll be whacked down to 2,000 shares, lose, 75% of the value. So now
Then it'll drop again.
then, as
Yeah.
shorts are going to pile on. They're going to whack it back down. It'll happen again. It'll be this vicious cycle. So, do you suck it up now and push to say, no deal, fucking liquidate it and be done now? Or do you suffer through another 2 years and watch, again, this is my opinion. I don't know this is going to happen, but having seen these types of things now over the last 5 years repeatedly, do you suffer through? I mean,
or there's alternative too. I mean, we could take the point, like, we want the deal to be done properly. So if you want to do it, then let's do the proper due diligence. Let's carry it all out, and then let's alter the terms of the deal so that the voting control is not as situated, so they don't get, because the three issues on the preferred B were voting control, the dividend, and the distribution upon.
Do we know how many shares GTI is authorized?
It just 1,000.
What's on the shelf? Do we know?
Oh, I think they said 500,000 preferred.
Yeah, but they're not going to issue preferred. How many common shares are on the shelf?
Like 300 million, something like that.
So is that what's out there, or is that
that's what's on the last financials? In the 300s.
So what's sitting on the shelf right now?
I don't know. Because there's some concern, and this might, again, I'm not trying to be cryptic, but there's some concern that perhaps that some parties may have issued other shares, and perhaps some of the wording and documentation has to address that potentiality too. So I think there's a lot of nonsense that's going on in the background. I'm not accusing, by the way, when I mean nonsense, I'm not saying the receiver or anything like that. I just mean in terms of the conduct that we've all heard about. There's a lot of stuff, and even though you've heard about a lot of it, there's no reason to expect that it won't continue, to some degree. So that's a fight. But what as the JR said, and I agree, and this is something, by the way, that I've presented. So it's not like this is new. But the question is, and this is the question I have, and obviously we don't care because we get no financial benefit out of this, so we're here for the ride,
right.
And to some degree, in terms of, and I'm speaking for JR, it won't change my life if I get nothing out of this. And in fact, I've in my head, it's nothing. In my head, the value is nothing. But to other people, I know it's different. And
right.
And I know, because I saw it at MMTLP, that people could suffer a lot if they're married to a possible resolution that doesn't come. So again, is it possible? Is it possible that AIversity is going to end up being Amazon? It certainly is, but most likely not. I mean, in the grand scheme of things, probably the odds of that are very unlikely. So if that's the case, do you want to take the route of being tortured for 2 years? And like every 3 months they dilute when they have to do a cap raise. And
let's go back just one hot second, because someone said, well, why are they going to do a reverse split? Do they want to get uplisted to the New York Stock Exchange? No, the answer is they don't. They're going to do a reverse split, though, because right now the share price is 4 cents. They can't issue more shares at 4 cents. That doesn't bring in any money. So they've got to do a reverse split in order to increase the share price, and then they can dilute.
Yeah.
I mean, I can tell you right now, that's what's happened. CRTD, Creedon did it. He did a reverse split, and then about 6, 7, 8 months later, he issued new shares. Yeah. Okay? That's all they can do. That's how they raise money.
And it's also not uncommon that the shorts come in when it gets raised, because then they have less risk.
There's value there.
Yeah, the problem is at 4 cents, their risk is great if you're in a short position, because you got very little upside and a huge downside.
Right.
When
But
when it's
the
at a buck,
reward is not real. But at 4 cents, the reward's not really worth it to short.
no, but it's not just the reward, it's the risk. They got they got, an upside of what, 3 cents, 4 cents, and a downside of unlimited. That's a bad trade. When it's at a buck, they can hack it down and their risk is much lower. And we've seen, again, we've seen that over and over it again. And that, by the way, that has nothing to do with the good faith intentions of any of the players of the companies, because a lot of times we notice that the management kind of didn't know that they were going to get screwed. They kind of eventually learned it. So that may be the case here too. And if you hadn't, didn't have a prior experience getting screwed, whatever. But my concern is, again, and again, I'm willing. So for me personally, I'm going to object to the deal on the grounds that I don't think we have enough information, and on the terms. But there may be other people that have different a view. And again, if you feel differently, please express it to the court. Because again, our point here is try to give you information, but for you to be able to kind of express how you feel. Hopefully whatever we're telling you is, helpful information. Whatever we pointed out, I think, are issues. The question is, and it's really the dynamic question, is if the company is on verge of basically liquidation, do you want to, take the deal in order to stop it? Or are you willing to risk it to find some other deal that is less onerous on us shareholders and perhaps brings some immediate cash into the company? Now, again, I asked, and I don't know because nobody's told me, but I asked for whoever had a prospective deal, and a couple of people contacted me, but I asked for any prospective parties to contact the receiver's counsel directly. We don't know. As far as I know, I don't know if anybody contacted them, but if you did and you presented some kind of proposal and you think it's better than the proposal that they're accepting, then there's no reason why you shouldn't come to that hearing on the 19th also and inform the court of that. I don't know if the receiver will. I don't know if the receiver will be asked. I would certainly ask the receiver, but I'm not counsel. I'm only some guy.
We're only shareholders.
Yeah, we're only shareholders. So again, that's the question. Do you want to risk a dissolution completely and try to find a better candidate, or risk that some regulatory body won't shut them down until we have enough time to figure out things? Or you're just willing to kind of accept it as is, or with some modification of terms? Do you see a question that caught your attention?
I'm covering it. Someone just said here, Richard, you reported multiple $1-million deals contacting you.
Not since we heard about this merger. No, that was like a year ago, or I had a bunch of contact from parties. I don't know if they were legit. I don't know if they contacted what they did. I wasn't representing them, nor did I control them. I was referring to, since I think when we found out about this deal, I said, anybody, we did a live stream. Anybody who has any deal, contact them.
I think, we go back to what we said earlier. The court link, the hearing link is on the receiver's Twitter page. If you're going to show up, make sure you're, dressed appropriately, and make sure you talk professionally. It doesn't matter what your opinion is, just make sure you convey it professionally.
Yeah, and again,
this is one of those times where your voice matters. The judge is going to listen to you. They're going to hear what you have to say. So if you're going to show up, just do it professionally and look professional.
Yeah. And try to be succinct. And if you have a reason, state your reason. In other words, don't just object. If you object to the deal and it's because of X, Y, and Z, feel free to state that, because that'll be more compelling to the judge. If the judge just hears, 50 people just saying, I object, whatever. If he gets a little more substance, then he might be more inclined. And again, I'm not saying this may not end up being a bad result, but I don't think we have enough at this point in time to accept it as written. And I don't think it's clear enough. And I think that other things can be done.
Well, we only got 25 minutes, so what else did you want to talk about?
What else did I want to talk about? Well, we talked about, there's a valuation. So one of the documents that's attached is a valuation. And what they do is I think they valued the company at it's approximate, like $34 million, even though it has zero revenue.
Well, there was 5 different methods of value.
Yes.
One of them came back at $34 million.
No, I think what they did is, there's 5 different methods. Let's say venture capital was like 29 million. There was something else that was 30 million or something like that. And then there were 3 that were like $1 million. So there was quite a disparity. And based on that, so like the math, 2 at 30 and 3 at 1, they figured 34.
Yeah.
Somehow. So I don't really buy that. I think, the value at this point in time is a drain on cash. That's what it is. And in terms of the valuation, so that's one thing they used to make a determination of the valuation. And, we're making fun of this. So maybe some of this is just kind of pro forma. In other words, you got to do it. Even if it's nonsense, you still got to do it. But what they do is they listed their competitors. So I'm just kind of like, we're being real here. So one of their competitors is XAI, OpenAI, Sam Altman's company. That's number 1 on the list. So they list as a competitor. Now, just comparing the two. So these guys apparently, and I don't know why, by the way, I don't know why they don't have any revenue, because that's another question. They have 30,000 users, but no revenue. Why not? I think they're doing some type of program, a check. I don't know how long it is. We don't know, but they have 30,000 users, and Sam Altman's company has, as of December, 300 million. So we figured that was 10,000 difference, and it's rolling. So I would not consider that to be my competitor if I were looking at it. That would be like a fly on the wall. So
they're not even in the realm of being acquired by them.
So, I mean, again, it might be great. They might have great technology. But we have no idea what it's worth. And we won't. So if you decide, in my opinion, if you decide to go forward with the deal, it's because you want to roll the dice and you hope they won't dilute, and you hope ultimately that whatever they generate creates value.
Right.
If you are against it, then you don't think it will generate value. You might think the deal's too speculative, or you're not willing to wait. And alternatively, and everybody's entitled, everybody certainly is entitled to create their own terms, but we all kind of know the terms. The 3 real terms are the voting, the dividend, and the distribution of that $4 million priority distribution. Those are the 3 main terms. And the issue of the money, what are we, is it an unlimited, or, like an alternative I thought of is if they're going to dilute, let's dilute the preferred too. So for every share that's diluted of the common, dilute the preferred, and that way they'll think more than once before they dilute, because they'll be hurting themselves. I don't know if that's the solution, but that's something that occurred to me, because usually the dilution is only going to be at the common. But if you have like specific terms in this transaction, and again, you could read the website. I think it's been posted, AIversity. You could read about them and what they do, and maybe it intrigues you, perhaps. Who knows? Maybe. And again, maybe it's great. I'm not saying it's not great. I'm just saying, for the purposes of staying in business in the short term without something else that's going to circumvent this, it ain't good. And the other thing I don't know, the other thing that makes me concerned is if they do this deal, and if we have to basically fund the deal, what happens to the legal? Where is that going to be funded by?
Right.
Who's going to be paying for for the receivers council and everything that's with that has to be paid for too? How is that going to be funded? By more dilution.
That's right. So, I mean, it's their only source of income right now.
Yeah. So, if in turn these guys show that because I think they said that they are hoping to generate revenue in the second quarter. I don't really know what that means, by the way. But if it turns out that they're bringing in a boatload of money and the equation is that they're carrying their costs, okay, that's a different scenario. But from what they presented, there's no way of determining that. And it doesn't sound like they're making a dime as of now. The way that I think what they do is their primary source of revenue is going to be some type of subscription service, like a monthly subscription service. But as of now, they're collecting $0. How long is that going to be? What are they going to collect? How much money is it going to cost them to generate that? How much money is it going to cost them to generate a user base? I think they said that their net user base, they anticipate to be about 400,000 in 5 years. So how much money is it going to cost them to get from 30,000 to 400,000? And to be honest, 400,000 seems like an insignificant number when we're talking about, in these parlance of AI. That sounds like a trivial amount. I don't know if the figures are accurate. I presume, like when I looked at all their figures, I presume they were all wrong. I just assumed I just ignored them. That really wasn't my issue. I wanted the deal to be straight, and I didn't think this deal was straight. Not that anybody had any illicit motivation. I just thought, again, like we were saying, somebody feels rushed, has to get something done. It looks like it's rushed. This is not the best deal. And again, if it's the only deal, okay. But if it's not, then perhaps we could find something better or alter this into a state where it makes sense. Any other questions there that you saw that?
Well, there's an interesting conversation going on about colonoscopies.
Okay. I'm a big fan. A big fan of colonoscopies.
I was like, oh, okay. Hey, we're here to talk about what you want to talk about.
Yeah, we'll do a video on colonoscopies next week if you want. I'm trying to think of anything else that is useful. You could read the documents, but ultimately, I think you just got to accept. I think you have to accept the possibility that we're going to get diluted, and if you're okay with that, then so be it. If you are willing to risk not getting anything at all, then you want to take a pass here.
Right.
I think that's the two. And again, maybe after they document it and explain it and correct it, it's a good deal. Maybe that too. Just not in the current form. This is going to be communicated, by the way. I'm working on something. I'm going to communicate it to our counsel. Oh, that's one thing I wanted to do. So along with that is anybody who's a plaintiff in the case, the White Rock versus Reichman case in Nevada, anybody who's a plaintiff in that case, whatever your opinion is, if you agree with going forward with the deal, or if you don't agree with going forward with the deal, let me know. So you all contacted me by email when we set this up. So why don't you contact me and let me know? And that way I can let our counsel know, because there's a couple hundred, I think they're like 250 plaintiffs. And the way it's set up, I believe, is it's a majority vote. So it's not a share vote, it's a majority vote. So if you have a position, yay or nay, please let me know and I'll pass it on. If any of you other people out there, if you're not going to participate in the hearing on the 19th, but still want us to consider your comments, send us your comments about what you think and how you want, in other words, if we get comments from 80 people and it's the same comment, we can say a lot of people have this, So feel free to let us know. Yes.
You're getting questioned. This is like the second time or third time I've seen this. Whatever happened to Torrento?
Torrento, I think, they did contact me. I told them to contact the receiver. I don't know if they did, but they did contact me. I didn't. Again, I'm not involved like in the details or anything like that. Literally, they reached out to me and I directed them to the receiver.
Right. So, well, that's all you can do. You can't speak on behalf of the company or the receiver.
So I don't know. I don't know. I presume that the receiver is aware of them, and I know that Trento was aware that if they wanted the receiver to be aware of them, where to contact the receiver. So, and I don't know why somebody else asked me about a potential deal, but I don't know if they contacted the receiver also. I don't know. I wasn't, again, I tried to stay away from the details of any transaction because I didn't want to be involved in that side. Any other questions that caught your attention?
There was a couple of questions about what's going on with Alpine. I mean, we've talked at length about what was going on with Alpine.
Yeah, I think we're just waiting. It's in a state where it's going to have to be reviewed by the,
we have to remember down to the trial judge. It's going back down to the trial judge.
Well, we also have to remember the administration has changed. Right. So we do not know, notwithstanding whatever Alpine did and does, we just don't know how enforcement's going to be handled by the SEC.
Well, that brings up a good point because there was just a memo that all current enforcement actions or new enforcement actions need approval by the administration.
I saw that too.
Yeah, I was just talking about it yesterday morning on a space. So the short answer to what's going on with Alpine is we don't know.
Yeah, and the reason why we suspect that the SEC and those kind of people would know about GTII is because of the relationship of Alpine to GTII. And we know the SEC obviously is aware of Alpine because they have been involved in litigation with Alpine. Any other questions that you saw that caught your attention, JR?
No.
So anybody else?
I mean, I'm trying to monitor, but no, those were the two big ones.
Does anybody else, if anybody else has any questions, now please speak or forever hold your peace. So I was going to say, from this point in time, I'm drafting an objection. I'm going to present it to our counsel, and I may post it. You guys can use it if you want, as kind of however you want. But it's not certainly not. I'm not telling you to. I'm just showing you what I'm filing or suggesting that I'm going to file. And it's, again, I think it's more focusing on terms.
So hold on, we got another question. And then someone said that's a good question. Kathy, how can 4 cents be more diluted? They're not going to dilute it 4 cents. They're going to reverse split it so that they increase the share price and then they're going to dilute it.
Yeah, if they do 100 to 1, that's $4. And that's where they'll do it. Start from there. And and again, no guarantees, we're no experts. It's not financial advice, but we saw a bunch of it that seemed to be like a common thing. I guess the only difference would be shorts may be treated differently with this administration. We know that like Hindenburg went out of business because they were apparently working with.
It better be. That's why I voted. JR, I have a question above. Brent, you're going to have to tell me, you're going to have to rewrite your question and I'll make sure I'm looking because I don't want to mess with it because I don't want to screw my screen up. So just retype it, bud.
But anyway, a lot of the shorts are going to go out of business, perhaps.
Al Rogman, it's perfectly okay to talk about colonoscopies. I just got a chuckle out of it. You can talk about whatever you want in the chat as long as it's friendly and appropriate.
You can talk about colonoscopies, but
JR, read my question above. Guys, I can't
come on, JR. Any info in Trento we answered.
Leader landscape, just please retype it. I don't want to touch my mouse pad because I don't want to lose the chat. Section 4. What about section 4, bud? Okay, here comes Brett. Can we request the judge to reissue shares so that would make Alpine forced to be buying back the fake ones in the system?
I think I don't know, but I would say this. My understanding is the receiver is going to seek a share count. That's what I heard.
Leader says double. That means sorry, Richard. I didn't mean to read that out loud.
Oh, whatever. The receiver apparently is going to seek a share count So, and one of the things we thought about was the Sorrento situation, right? We talked about that too. The Sorrento bankruptcy is a way of potentially resolving it, but that's really complicated, and we don't know if it's a superior way than this of trying to get to the end. Dividends are toast. Yeah, I mean, I'm not relying upon, again, I told you my view is in my head, I count it as nothing, and hopefully can get it from there. The
Leader,
dividend,
I'm not understanding your comment. What are you referring to? Double instead of 4 million, 8 million. Dr. Squint wants to have a look at the third
I think
eye.
he's talking about the distribution, the 4 million, I think.
$4 million, but that's referred to if there's that's it. Section 5 is if there's a liquidation.
Yeah, the dividend was 2x, but it wasn't like super clear, but it seems 2x. So if there's 1,000 shares, if there's 1,000 shares and it's $2 dividend, it should be $2,000. That's kind of how it looks, but it's hard to tell because the previous section is
so leader. There's two different things going on. Section 5 that refers to the $4 million is in the event of a liquidation.
You're referring to what, just so everybody knows?
But Section 4, which is what he just said, is each holder of Series B shall be paid twice the amount of dividends issued by the company to holders of common stock. Yeah. That's so if the holder of common stock gets 1 cent, the holder of the preferred shares, the Series B preferred shares, gets 2 cents.
Yeah, and just like in a little example, like a twist off of that. So the concern is like if you give up voting control, then the guys with control can do whatever they want. So how about if they decide, you know what? How about we only give dividends to preferred B shareholders? Right. Let's do that. They can basically do whatever they want. And right. That's the real concern. In essence, if you do that, you just have to rely upon the good faith of whoever's running that particular operation, because right. you lose control. And the other part is, part of the reason we were able to get this into court is because enough shareholders got together with enough percentage of voting interest that might disappear by that. But again, it still might be the best decision, because you have to decide for your own personal stake. Do you want to go forward or do you not want to go forward? And again, the judge is inclined to approve the transaction just going in. That's going to be his inclination, and he's going to have to be compelled not to, if that's the way you decide. And again, I'm clear and open. I'm going to object to it because I don't think it's clear enough in the deals. Not my view. I think JR is in agreement on that. He might have been a little.
Yeah. Get their 4 million first. Leader, I think you're confusing things. There's no $4 million if there's a dividend paid. The $4 million is if there's a liquidation. So if the merger happens and then they liquidate, if there's assets that aren't equal to $4 million, no common shareholder gets anything if there's nothing more than $4 million. All of that goes to the Series B preferred shares.
Yeah, I guess he's saying that if the liquidation event is the payment of a dividend, then can they then get
and right, the key verbiage here is voluntary or involuntary dissolution, liquidation, sale of all assets, sale of company, bankruptcy, reorganization, or winding down of the company.
Yeah,
I mean, right now, honestly, there's not $4 million worth of assets. Right now, what is there? I don't even think there's $1.8 million.
Less.
So there's less than $1.8 million.
Yeah, there's claims. there's claims, for millions, multi-millions, right. But they're in terms of the actual current assets, it's tiny. Part of it because to get to this particular spot.
Right. Well, does anybody else have anything else? I apologize. I have to jet. I gotta go get my mom something.
So again, just kind of participate. We want everybody to participate. If you are for it, great. State your opinion. If you're against it, great. State your opinion. And if you have a reason, state that also. Try to be succinct and professional if you appear. If you have questions in the meantime, reach out. For those that are in the plaintiffs group, I'm repeating that, reach out, send me an email, your name, for or against, because I'll check it against the list of plaintiffs. Because again, I'd like to advise the attorney how it breaks down. And again, the more participation, the better. We really want, we're not deciding this. We want everybody to like have a voice. That's kind of the idea.
So the other question, I'm sorry, I don't mean to interrupt you, but
Yes, you
I'm
do.
seeing a bunch
Yes,
of questions on the dividend shares that were issued. Now,
Yeah.
I paid very little attention to that when it was happening. So
Yeah.
do we have any understanding of what's going on with those? Or
I would say,
what actually happened?
realistically, I think it's probably not gonna, they're not gonna be valid or issued. I don't think that in the grand scheme of things, I think to the receiver, that would end up being, way down the line. So I don't know for a fact. I don't know for a fact, but I don't think it's the priority.
Silver Minecraft, the silver minecart. You have no idea how appropriate that comment was, considering the colonoscopy discussion that's above. He says, so basically we need to lube up because we're going to get F.
Yeah, well, listen, we can get lucky. We have to hope to get lucky. So if the deal goes forward and again it works out.
Well,
otherwise,
otherwise,
I don't have like high expectations. I'm hoping to be pleasantly surprised. And listen, this weekend, I have a bunch of IBIT. It's this Bitcoin ETF. So this weekend, when the tariffs were announced on Friday, I watched it just go down in the toilet, and it came almost all the way back today. So you never know. We have to hope that we got whoever is this entrepreneur adversity, they're good.
Well, here's my parting comment. That I have to go. I apologize. Normally I love to just BS, but I gotta take here something. My parting comment is: look, at 4 cents, we've already been lubed up and taken care of. Okay, I mean, it's not going to get much worse. It just, I mean, how much worse can it be at 4 cents? So I do need to go though. She's downstairs coughing and hacking. Okay. I got to figure out what's going on.
Okay. Well, again, what's worse? The last comment. What's worse if it gets reversed to $4 and then goes back to 4 cents again?
Yeah. Well, right. That's right.
That's what's worse.
To me, that's just as bad as liquidation.
Yeah.
I mean, the only thing there is now it's just going to take longer, and it's kind of like.
And again, what I said was it's to me, and I expressed this. That's a mental health issue. Is it?
Well, think about it like this. It's like anybody that sues for wrongful death. If you sue for wrongful death, you're going to have to relive that death 1,000 times during depositions and hearings and interviews. This is really no different. It either dies now and it's over, or it's going to take another 2 years for it to die. I'm not saying the company's going to go out of business, but my personal opinion is they're going to reverse split, dilute, split, dilute.
And until it's tradable, we can't take advantage of any of those moves, right? If there's an acquisition, usually an acquisition would trigger like something, but until it's tradable, we can't. And they're trying to use that as the means to get it tradable. So I don't know, what the impact is like that. But again, it still might be the best decision. But think about like different terms that you might like to include that would make it a fairer deal. That, again, the judge would be interested in that. He's not going to just be interested in negative. He wants something constructive. And if we could make it a nicer package for all of us, then that's good.
Right.
Anything else?
All right, guys.
Thank you, everybody. Thank you, everybody. And any comments, questions, please throw them out there. And again, any plaintiffs, please let me know what you think. And everybody be well. Thanks for hanging out. Have a great evening and talk to you soon.
Bye, everybody.